Hello, and welcome to week 3 and our first section under the topic, the Unauthorized Practice of Law. As you already know from this week's module, the Unauthorized Practice of Law, or UPL, as it's commonly referred to, is covered in Chapter 2 of the course textbook. I highly encourage you to read it before completing the materials for this week. It really is a great resource. In many cases, it goes deeper and provides more depth than we'll be able to review together here online. With that, let's jump into the first section under the Unauthorized Practice of Law, or UPL, which is a brief history of how this area of the law was developed. Let me share with you a brief slide presentation that will help in our discussion. Now, first, limitations on who can practice law in the United States can be traced all the way back to the beginning of our country. In those days, courts began making rules regarding who could appear before them as attorneys and issued licenses to those who met the requirements. They also made rules about how much licensed attorneys could charge in fees. There were lots of reasons why the court did this, but it all revolved around helping to protect the administration of justice, preserve the dignity of the courts, keep clients from being harmed or exploited, and preventing excessive fees. In the mid-late to late 1800s, the first UPL statutes were passed, and these laws prohibited court appearances by anyone not licensed as an attorney, the practice of law by court personnel, such as bailiffs, unlicensed persons from holding themselves out as a lawyer, and non-lawyers from forming partnerships with lawyers. The definition of the practice of law broadened over time, beyond just making court appearances on behalf of clients to including preparation of documents by which legal rights were secured. And at one point, the definition expanded to include all services customarily rendered by lawyers. Now, during the Depression, state bars became powerful trade organizations, and it became a crime to practice law without a license in virtually all states. Now, efforts to prevent or stop the unauthorized practice of law, which were strong during the Depression and the years after, slowed in the 60s and 70s. And in addition, at that very same time, the sale of legal self-help materials were found by many courts not to violate UPL. However, efforts increased again during the 80s and 90s due to the number of independent paralegals providing low-cost legal services directly to the public. Now, in this context, independent paralegals are defined as those that do not work in support or under the supervision of an attorney, but rather on their own with clients directly. So today, about half of the states actively enforce UPL. Some more aggressively than others, some not as much. So that's it for this section. Remember to read Chapter 2 of the textbook, and I'll see you in the next section on trends in the unauthorized practice of law currently